Hello, my name is Stacy Backus from Hub Human Resources Consulting Services. This webinar is focused on providing need-to-know information on the new overtime rule that will go into effect on January 1st, 2020. This training will focus on understanding what the new overtime rule is, review a brief history of the overtime rule, discuss implications to employers, and what you should do next. The U.S. Department of Labor announced a new salary threshold for the Fair Labor Standards Act's white-collar exemption from overtime pay, effective January 1st, 2020. This is something that's been done sporadically since the FLSA was enacted. New requirements apply to any position classified as exempt under the executive, administrative, or professional exemption. However, there are a few professional exemptions that have no salary requirement, such as for teachers, doctors, and lawyers. They're unaffected by the new requirements. The new overtime rule does not include any changes to the duties test in determining if a position is exempt or non-exempt. What are the details outlined in the new overtime rule? The new rule will raise the salary threshold to $684 a week from $455 a week. A blocked Obama-era rule would have doubled the threshold, but a federal judge held that the DOL exceeded its authority by raising the rate too high. The new rule does not create different salary levels based on region of country. Under the new rule, non-discretionary bonuses and incentive payments, including commissions, paid on an annual or more frequent basis may be used to satisfy up to 10% of the standard salary level. In addition to raising the salary cutoff for exempt workers, the new rule raises the threshold for highly compensated employees from $100,000 a year to $107,432, of which $684 must be paid weekly on a salary or fee basis. The increase is about $40,000 less than what the DOL initially proposed because it's based on the 80th percentile rather than the 90th percentile of all full-time salaried workers' earnings nationwide. Unlike the overtime rule that President Barack Obama's administration put forward in 2016, the new rule doesn't include automatic adjustments to the exempt salary threshold. The new overtime rule anticipates the reclassification by employers of more than 1 million currently exempt workers as non-exempt, as well as an increase in pay for others above the new threshold. In order to provide context to the new rule, it's helpful to understand the history of the overtime rule. The overtime rule was established when the FLSA passed in 1938. The new law established a minimum wage, overtime pay, record keeping, and youth employment standards affecting employees in the private sector and in the federal, state, and local government. In addition, it created 2 employment classifications, exempt and non-exempt. In 1938, the first overtime salary level threshold was $1,560 for the executive and administrative function. The overtime rule was revisited again in 1940, 1958, 1970, 1975, and 2004. The last salary threshold was raised to $23,660 annually for all white-collar exemptions in 2004. In May of 2016, under the Obama administration, the Department of Labor published a rule to raise the overtime salary threshold. This was the first time since 2004. The increase to the salary threshold was from $23,660 to $47,476. The rule was scheduled to take effect on December 1st, 2016. Just 10 days before the implementation date of the final rule, a federal judge in Texas temporarily blocked it from taking effect. With regards to the 2016 proposed overtime rules, industry groups relayed concerns of potential layoffs, reduced employee benefits, and diminished customer service. These are just some of the reasons why many employers oppose the 2016 proposed revisions to the overtime rule. Most of these businesses didn't oppose having a minimum salary level for overtime, but felt the increase under the final rule was too much too fast. The Texas court found that the federal rule exceeded the DOL's authority by making overtime status depend predominantly on a minimum salary level. Employees who are clearly managers with the authority to hire and fire would have been reclassified as being hourly rather than salary workers, which the court held violated the FLSA's intent. 21 states had filed emergency motions in court in October 2016 to prevent the rule's enactment. Employees and employers have both been waiting in anticipation for the latest salary adjustment. When considering the new overtime rule, the DOL agreed with public commenters who said waiting too long to make updates causes problems for employers and workers. Among other reasons, delays cause future increases to be larger and more challenging for businesses to absorb. The DOL initially aimed to recommend salary threshold updates every 4 years. However, this proposal was dropped. In order to understand the new overtime rule, it's important to clarify what type of an employee would be exempt versus non-exempt. An exempt employee is excluded from minimum wage and overtime regulations. Employers must pay a salary rather than an hourly wage for a position for it to be exempt. Typically, an executive, supervisory, professional, or outside sales position would be considered exempt. Exempt employees are not covered under FLSA rules. They are paid a salary rather than an hourly wage, and they must earn $684 a week as of January 1st, 2020. Exempt primary duties must work directly related to the management or general business operations of the employer or the customers. In addition, the exempt employee would need to exercise discretion and independent judgment with respect to matters of significance. A non-exempt employee is not exempt from FLSA requirements. Employees who fall into this category would be paid at least the federal minimum wage for each hour worked, and then given overtime pay of not less than 1.5 times their hourly rate for any hours beyond 40 each week. An employee who earns less than $684 per week as of January 1st, 2020 is considered non-exempt, although their wages may be higher. How will the new rule impact employers? Exempt employees who earn less than $684 a week would need their salary adjusted to meet the new threshold or be reclassified as a non-exempt and paid overtime. The financial impact will depend on the number of hours exempt employees work. The new salary threshold will affect workers at companies of all sizes. Small businesses with a smaller revenue cushion are likely to feel the impact of higher overtime costs. In other words, the new overtime rule is expected to result in the reclassification by employers of more than 1 million currently exempt workers as non-exempt and an increase in pay to bring others above the new threshold. According to the New York Times, business owners who don't want to pay additional overtime have said that they were exploring options, including giving affected employees raises to put them into the category of exempt workers. Employers should weigh the cost of raising employees' salaries above the threshold against the cost of reclassifying employees as non-exempt and paying overtime. In considering these decisions, ensure compliance with workers' duties and exemption criteria. Consult with HR or outside counsel if needed. What should employers do next? Employers should conduct an FLSA audit and establish a plan. This entails a review of your workforce, conducting audits by assessing job descriptions and reviewing budgets. Employers should immediately pull data for exempt workers earning below the threshold, evaluate exempt and non-exempt classifications, and identify potential vulnerabilities. Employers will need to calculate potential costs. Keep in mind that non-discretionary bonuses and commissions paid on an annual or more frequent basis could be used to satisfy up to 10% of the standard exempt salary threshold under the DOL's proposal. Leaders need to anticipate the impact of possible changes within the workforce and organization as it relates to morale, organizational structure, and recruiting future talent. Finally, develop a training and communication strategy. For impacted employees, they need to feel that this new change is not a demotion. Be clear these changes are based on new government rules. Also, employers should evaluate their systems for timekeeping, tracking overtime, and paying bonuses. How can Hub help in anticipating this change? Hub can conduct an FLSA audit, create and revise job descriptions to ensure that they're legally sound and actionable, identify and work through the impact of exempt and non-exempt status changes, and work with stakeholders to analyze future staffing needs as they may relate to these proposed overtime rule changes. More broadly, HRCS works with stakeholders on HR strategy and planning, training design and delivery, change management initiatives, development of affirmative action plans, HR audits and compliance, talent acquisition and retention, policy development and handbooks, as well as management of employee engagement surveys. Thank you for your time. We hope that this informative session has helped prepare you for these upcoming changes. Have a wonderful day.